Suits against entities without juridical personality. When two or more persons not organized as an entity with the juridical personality enter into a transaction, they may be sued under the name by which they are generally or commonly known. In the answer of such defendant, the names and addresses of the persons composing said entity must all be revealed. Big AA Manufacturer vs. Antonio. Petitioner is a sole proprietorship registered in the name of its proprietor, Enrico Alejo. Respondents filed a complaint for illegal layoff and illegal deductions before the NLRC's Regional Arbitration Branch. They claimed that they were dismissed and sought separation pay from petitioner. The issue in this case is whether or not Alejo can be held liable. The Supreme Court ruled that Alejo, as the sole proprietor, is liable to respondents for back wages and separation pay. The court noted that Alejo is consistently represented as petitioner's sole proprietor in its pleadings, including this petition. Therefore, respondents properly sought the inclusion of Enrico Alejo as a proper or indispensable party to the case. Strictly speaking, he is the proper party in the case and the one liable to respondents, for petitioner has no juridical personality to defend the suit. The court held that a sole proprietorship does not have a separate juridical personality that could enable it to file a suit in court. In fact, there is no law authorizing sole proprietorships to file a suit in court. A sole proprietorship does not possess a juridical personality separate and distinct from the personality of the owner of the enterprise. The law merely recognizes the existence of a sole proprietorship as a form of business organization conducted for profit by a single individual and requires its proprietor or owner to secure licenses and permits, register its business name, and pay taxes to the national government. The law does not vest a separate legal personality on the sole proprietorship or empower it to file or defend an action in court. Still on sole proprietorship, Ejercito vs. M.R. Vargas Construction. Petitioners filed a petition for injunction before the Quezon City RTC. The petition named M.R. Vargas Construction Co., represented by Marshal R. Vargas and Renato Agarao as respondent. The issue in this case is whether the trial court acquired jurisdiction over respondent enterprise. The Supreme Court held that a sole proprietorship does not possess a juridical personality separate and distinct from the personality of the owner of the enterprise. The records show that respondent enterprise M.R. Vargas Construction Co. is a sole proprietorship and, therefore, an entity without juridical personality. Clearly, the real party in interest is Marshal Vargas, who is the owner of the enterprise. Thus, the petition for injunction should have impleaded him as the party respondent either simply by mention of his name or by denominating him as doing business under the name and style of M.R. Vargas Construction Co. It was erroneous to refer to him, as the petition did in both its caption and body, as representing the enterprise. Petitioners apparently realized this procedural lapse when in the caption for certiorari filed before the Court of Appeals and in the present petition, M.R. Vargas Construction, Marshal R. Vargas, and Renato Agarao were separately named as individual respondents. Okay? So, since respondent enterprise is only a sole proprietorship, an entity without juridical personality, the suit for injunction may be instituted only against its owner. Accordingly, summons should have been served on Vargas himself, following Rule 14, Section 6 and 7 of the Rules of Court on personal service and substituted service. In the instant case, no service of summons, whether personal or substituted, was effected on Vargas. Association of Flood Victims versus Commission on Elections, This is a resolution in 2014. The facts in this case are as follows. In their petition, it is stated that Petitioner Association of Flood Victims is a non-profit and non-partisan organization in the process of formal incorporation, the primary purpose of which is for the benefit of the common or general interest of many flood victims who are so numerous that it is impracticable to join all as parties, and that Petitioner Hernandez is a taxpayer and the lead convener of the Association of Flood Victims. Well, the Supreme Court held that Petitioner Association of Flood Victims is an unincorporated association not endowed with a distinct personality of its own. An unincorporated association, in the absence of an enabling law, has no juridical personality and thus cannot sue in the name of the association. Such unincorporated association is not a legal entity distinct from its members. If an association, like Petitioner Association of Flood Victims, has no juridical personality, then all members of the association must be made parties in the civil action. In this case, other than his bare allegation that he is the lead convener of the Association of Flood Victims, Petitioner Hernandez showed no proof that he was authorized by said association. Aside from Petitioner Hernandez, no other member was made signatory to the petition. Only Petitioner Hernandez signed the verification and sworn certification against Forum Shopping, stating that he caused the preparation of the petition. There was no accompanying document showing that the other members of the Association of Flood Victims authorized Petitioner Hernandez to represent them and the association in the petition. So take note the difference between plaintiffs and defendants. An entity without juridical personality cannot sue in its name. So like in this case, the Association of Flood Victims should have named their members as the party plaintiffs in the action. Whereas if it is an entity without juridical personality as a defendant, they may be sued under the name by which they are generally or commonly known. In the answer, however, of such defendant, the names and addresses of the persons composing said entity must all be revealed.